back, 'cause it was crowded. After all, she made no mention of being sexually assaulted at all. He then says it was nice having his cousin around to spend time with when his wife was at work, that it would never cross his mind that Daniel would do something like that. But he knew he didn't want his wife around any man the day she says she drank those 4 Locos. We know this because she added that her husband didn't want her around Daniel the day she drank the 4 Locos. Fourth, her husband stated that he had a conversation with Daniel after it happened, and the detective asked while he was in jail. The husband said no. But the detective had been listening to him and Daniel's jail phone calls, so he may have just asked him if Daniel tried to call him since he'd been in jail to see if he'd tell the truth. The husband denied talking on the jail phone with Daniel 3 times. Fifth, his wife goes into more detail about the night Daniel tearfully told her that he just wanted her to want him, and how he also told her he was infatuated with her. She then presented a scenario where Daniel and her husband were at odds, and she got caught in the middle. So Daniel sexually assaulted her 6 times, and may have sexually assaulted his daughter to get back at him. Then her and her husband state that Daniel had several women, including her cousin, who were interested in him, but he never took advantage of those situations. The wife saying, "He had many options. You may be wondering why didn't either one of these parents in either one of these emergency interviews talk about their daughter specifically. Well, by then they had already received the negative results from the child sexual assault exam. Daniel was indicted for the felony 1 rape of Mrs. Newton Braxton on June 20th, 2011. On the 22nd, he pleaded not guilty and his bond is set at $50,000. On the 23rd of June 2011, William Davies was assigned to be the prosecutor. On the 28th of June 2011, Judge Jonathan Bender was assigned to the case, and on the 30th of June 2011, the public defender George Schumann was assigned to represent Daniel.
Hello, Daniel. I'm George Schumann. I've been with the public defender's office for quite a few years now. I've handled a lot of felony cases. I'll be representing you. So far, you're facing a very serious charge of F1 rape that carries 10 years. There's probably going to be another indictment with charges involving a child in the near future. That charge will carry life without the eligibility of parole. I don't have the discovery yet, so we can't go over the evidence. I'll meet with the prosecutor to see what's what. You got any questions?
My bond is $150,000. Is there a way we can lower that?
Yeah. I can put in a motion for a bond reduction hearing. In the meantime, stay out of trouble in there and call me and leave a message, and I'll come see you when I can. Hello, Daniel. Hope you're doing okay in there. I know it can be rough for somebody with your charges. I got your discovery. It's pretty thick. I'll look it over and come back and go over it with you.
I'd like to have a copy of the discovery. And when is the bond reduction hearing?
Clients don't usually want the discovery, but okay. The bond hearing's most likely in a few weeks. I've got a lot of cases, so I'll contact you after I look over the discovery. Looks like you've got a good judge.
There's a guy in here with a Black's Law dictionary, and he said everybody should have their discovery. What do you mean, good judge?
Well, Judge Bender's known for giving good deals.
I'm not taking any deals. I know you might hear that a lot, but I'm not. Thanks for the discovery, George. I'll talk to you soon.
Daniel has his first bond reduction hearing, where he learns the first prosecutor, for whatever reason, was not on the case anymore, and the new prosecutor, Megan Jewett, claimed in open court that Daniel's bond shouldn't be lowered from $150,000 because he wrote a threatening letter to the victim. The judge continued the hearing till the next day and asked Mrs. Jewett to produce said letter. Meanwhile, Daniel and George meet at the jail after the hearing.
Daniel, why would she say you wrote a letter if you didn't?
George, I told you in the courtroom that I didn't write any threatening letters.
Well, I guess we'll see tomorrow.
Yeah, whatever, man. I read this discovery, and it shouldn't be hard to get the bond lowered tomorrow when you tell the judge about all this wild shit she's saying and all the inconsistencies in the evidence, right? I think I should get in touch with a news reporter. Get some exposure for this. She said I raped her so many times. Why is this not in the news?
Well, Daniel, getting your bond lowered with such a serious charge won't be easy. No news. That would be bad for you. You said you weren't taking a deal. You want people to think you're a rapist before trial? And I feel it would be best to separate the cases. It will be easier for me to defend against them one at a time. Do you understand what you read in the discovery?
Yeah, I do. But I want to talk to you first about this letter I got from Child Protective Services. They said they did their own investigation. Right here it says evidence unsubstantiated. Allegations of child sexual assault unfounded. This is good for me, right? Do you have to admit this into evidence, or does the prosecutor already have it?
The prosecutor will probably ignore that.
Why? Because the story Mrs. Newton told CPS is different than the story she told the detective.
The fact is, Daniel.CPS is a Mickey Mouse organization, and Judge Bender isn't going to give any credence to their investigation. It's useless. So, no, I'm not going to admit that into evidence.
Damn, that's fucked up. Look, I've been reading this discovery, and a lot of things don't make sense. Mrs. Newton said she gave the diaper she found under the cover on the baby's bed to an officer before she was interviewed. If the detective took pictures of the crime scene after the interview, then how did the diaper get on the floor in the picture he took after the interview? If it was given to an officer before the interview, it seems Detective Tim Horning put it on the floor right before the picture was taken, or the officer did. Then I realize I'm reading all these statements because the detective recorded them. But he never recorded when he got permission to get a buccal swab out of my mouth of my DNA. Does he need permission for that? Because it's very clear by the police report that I was visibly inebriated and had to be awakened with an ammonia pack. I'm already going to jail. So, I'm in this stinking motherfucker watching SVU yesterday, and it made me feel like him getting my DNA while I was drunk seemed sus. So then I read the discovery some more, and I see that he wrote in his own report that he took all the evidence and left it in his office in the open air for 3 days to dry. That's why the DNA evidence don't add up. I thought you guys had an evidence locker for shit like that. You said he was a fraud detective. Is this how he handles fraud cases?
You're talking about evidence tampering?
So, whenever I say something like, why would you bring this big-ass red dog to my house and you know I'm allergic to dogs, you're then gonna say some shit like, so you're saying the dog's too big?
Look, Daniel, I understand your frustration, but that's a highly inflammatory allegation, and one we have to wait to tackle when I get him on the stand in cross-examination.
Okay, but he still didn't record getting the buccal swab, and it's the only thing he didn't record. That was shady, especially because even in my inebriated state, I didn't want to give a statement. So why would I consent to him swabbing my... None of that seems right. Even if he didn't need a warrant, I want to know he did it right.
Well, I'm going to have to get back to the office. I need to figure out what kind of motion to file to help with the buccal swab issue. Thanks for giving me all the feedback, and keep your head down in there.
You mean keep your head up?
Nah. I hear they're renovating part of the Franklin County Jail, so they're moving you guys to Jackson Pike. You got a sex case? It's probably going to get more violent for you. With the time you're facing, you don't need any new charges, so keep your head down. See you in court tomorrow.
Well, they had the continued bond hearing the next day. The prosecutor, Mrs. Jewett, tells the court that she couldn't produce the threatening letters because there are no threatening letters. The judge looks at her disappointingly and denies the motion and slams his gavel. George and Daniel discuss the case after court.
Daniel, I can't explain why that happened. Just know she's the prosecutor and she believes you're guilty, so she's going to do a lot of things you don't like.
Like lie, to influence the judge's decision to lower my bond.
Unfortunately, yes.
Can we ask to have the bond lowered again?
Yeah. I'll put in for another bond hearing later today. Also, Daniel, I just met with the prosecutor and the judge. I know you said you're not doing any deals, but by law I have to tell you. They offered you 12 years for both charges.
12 years? I haven't even got the other charge yet. It doesn't matter. Okay. You told me. The answer is no.
Okay, now that's out of the way. I came up with a motion to suppress unconstitutionally obtained evidence. He basically violated your constitutional rights by getting the buccal swab while you were intoxicated.
Look, that shit just didn't seem like it was done by the book, so I had to address it.
I gotta be honest, Daniel. I've never had a client as involved in their own case as you are.
Well, the homie with the law dictionary's been giving me a lot of insight. He's the one that convinced me to call my cousin. I wasn't gonna do it.
I don't. Understand?
I called my cousin, and he asked me to tell him exactly what happened. So I did. I figured he told his wife what I told him, and that's when his wife called the detective back, so she could make up a rape episode for each time I told my cousin when and where his wife and I had sex.
Oh, wow. I wondered why she did that. I did. Makes sense. Well, Daniel, I see there's no rape kit for your first indictment, along with her changing her story multiple times. I'm looking forward to trial. That cross is going to break the case open. Daniel, all that insight from your friend in there with the law dictionary. That's nice and all, but I'm your lawyer. I'm the one fighting for you. I'm your warrior. You gotta trust me and do what I tell you. And you'll be alright in the end. I'm gonna file for another bond hearing. It'll probably be a few weeks from now. Keep your head down, and I'll talk to you after the hearing.
Okay, George.
A few weeks later, Daniel appeared at the bond hearing, and after George stated the reasons for Daniel's bond to be lowered, the prosecutor Megan Jewett said in open court that Daniel's semen was on the diaper. The judge gave Daniel a disgusted stare as he waited for the prosecutor to give the judge the test findings because he wanted to see it. As he read over the results, the judge shook his head and shot Mrs. Jewett a look of annoyance. Then the judge says, "There is no semen on the diaper." "Why would you say it was?" Then the prosecutor simply said, "I apologize, Your Honor. I misspoke." The judge acknowledged her apology, gave her a mild reprimand, and denied the bond reduction, and slammed his gavel.
Okay, George, what the fuck is a misspoke? What the fuck is that?
Daniel, you gotta keep a cool head. There are a lot of things that go on in the courtroom you just don't understand. When the prosecutor said she misspoke, she was basically saying she didn't know what the fuck she was talking about, and that she should have gave the evidence a closer look. Prosecutors say it all the time.
Man, I ain't trying to hear that bullshit. Did you see the look the judge gave me?
Daniel, I know you're pissed, but you gotta trust me. We need to move on from that, and stay focused if you want to be ready to go to trial.
Whatever, man. She got the effect she wanted. Looking forward to her misspeaking at trial as well.
If we go to trial.
I know what you mean by that, and I need you to know I'm not taking any deal. I know you have to tell me, but you can just keep it to yourself, and we can act like you told me. This already some fuck shit. There's no need for us to have a disagreement, not only cause you asked me a question. You know I don't want you to ask, but one you already know the answer to.
If they offer you a deal, I'm gonna tell you, flat out, it is what it is. Alright. Good grief. It was like pulling teeth, just to get you to accept that I would be telling you about the deals.
Now what about the motion to suppress?
There'll be a hearing soon. We'll talk after. In the meantime, keep your head down, Daniel.
The hearing was scheduled. The judge denied the motion to suppress. Daniel was not at the hearing. Somehow there was a mix-up, and he was never taken to court. He and George speak afterwards.
Sorry about that, Daniel. It didn't matter that you weren't there anyway. It's probably better you didn't hear that news firsthand.
Why do you say that?
Well, it was your idea. More facts about that. Had the judge granted that motion, they would have had to throw out all that evidence because of something called fruit from a poisonous tree.
I just got my indictment. I've been indicted for rape by cunnilingus. What the fuck? How did this bitch procure this charge without evidence? How?
Don't take it personal, Daniel. They can indict a ham sandwich.
And just what the hell does that mean?
Well, Daniel, the prosecutor doesn't really need evidence to get an indictment. All she had to do is walk in there and show the grand jury. Which isn't really a grand jury. They're just regular citizens. She probably went in there and showed them the statements, and that's it. There's not even anyone there to defend you. So, yeah, she could have indicted a ham sandwich.
I'm starting to understand. The prosecutor just does whatever serves her. She didn't have to acknowledge the CPS investigation results. She completely disregarded common sense when it came to the multiple statements and bizarre recollections of Mrs. Newton. She done lied about the evidence several times in front of the judge to bomb the bond reduction hearings, and come to find out, before all that, she got off some loaded demonstration at the grand jury, so she could overcharge me to try to get me to take a quick plea deal, which on paper, it counts as a conviction for her, because if you take a plea deal, on paper it still says you were convicted of whatever crime you plead to. She is goddamn diabolical with hers, man. And I'm starting to feel like all you're giving me is a fucking play-by-play.
How many kids you got, Daniel?
I got 2 daughters.
How old are they?
Why are you asking me this?
Because when you go to prison as a sex offender, involving a minor less than 13 years old, you never get out. That's why it's called life without the eligibility of parole. That's what you're facing now, along with the 10 years for the first indictment. I'm the only person trying to prevent that. Do you get that?
But George, you ain't did nothing.
Daniel, tell me, who has shown up to court in your support?
My people came to visit the jail.
Exactly. I'm the only person in that courtroom in your corner, and you call me a commentator?
Hell yeah. You telling me a lot of stuff, man. But what information are you giving me that's helping? George, you ain't did shit but get the cases separated. Something I feel some kind of way about. But I'm not a lawyer.
Right, Daniel. I'm the lawyer. And you're worried about the wrong things. You're in here dealing with pretrial worries. I've been a public defender for many years. I've been assigned to a lot of trials. That means I know the system and the people in it. A trial is a lot of work, but it's where I shine. Daniel, I pride myself on my performance during a trial. And you're not going to diminish that by being stressed out. You said you want a trial because you're innocent. I want trial because I'm a trial lawyer. It's what I do.
I hope so. Because I ain't taking no deals. Look, George, I just been messed up since you told me how she got the indictment.
I get that, but that's why you got to trust me, Daniel. I got your back. Look, we're going to have one more pretrial, then we're going to ask for a trial date. I got to go. I'll talk to you in a couple weeks.
Okay, George.
Okay, Daniel. We got trial in 2 weeks. Key things I'm going to stay focused on. First thing, there's no rape kit. Why? Because she refused it, saying that it wouldn't work because she had had sex with her husband that same day. Was she trying to hide another sexual partner by refusing the rape kit? We don't know, but I'm going to ask. Second, the multiple stories. She also said in her third statement that she wasn't in her right mind when she gave her first statement. It won't be hard to expose her lies during cross-examination. Third, her own friend gave a statement saying she was told y'all had consensual sex. Fourth, she says she never told her friend you had consensual sex, but says she didn't tell her friend everything. I'm also going to ask her about the day she told her boss, but then left work early to hang out with her friend. I thought it was odd that her friend said that her husband realized she wasn't at work, and she then had to go home. All this, and she never once told her husband she was being sexually assaulted. All these things create a tremendous amount of reasonable doubt. It's not a slam dunk, but the prosecutor is looking at an uphill battle, to say the least.
George, when that detective gets on the stand, I need you to ask him. If the diaper was found under the cover on the bed and was given to the officer before the interview, and he took the pictures after the interview, how did the diaper end up on the floor in the picture?
You really expect me to accuse this detective of evidence tampering in open court?
These motherfuckers have charged me with rape by cunnilingus with nothing but circumstantial evidence. And now I'm facing life, George. You said you were my warrior. You said you would fight for me. There are more than enough clues for a goofy motherfucker to see that Detective Horning tampered with evidence. That needs to be highlighted. That's like extra reasonable doubt.
Okay, Daniel. I said I would, and I will, when the time comes.
Daniel and George spend the whole morning picking half the jury. The prosecutor, Megan Jewett, hadn't objected to any of their selections. Then Judge Bender calls a recess. Even though Daniel has on a suit and tie, he's still incarcerated, so he's put in the holding cell right next to the courtroom.
Why'd the judge call a recess? How long am I going to be waiting?
Don't worry, Daniel. Recess is a part of the trial process. I know you feel like you want to put belt to ass, but there are also other people involved in this same process, namely the jurors. They needed a break. Looking at the rest of the pool, I think we're doing well. I feel like we need to get as many black women as possible, though. They can spot bullshit quick, and they ain't afraid to voice it. We don't want any white men, but if we do, they have to be younger. Are there any white women you feel like we should have?
Well, if I had just one, it would be the brunette in the white shirt.
What makes you so sure?
The eyes. They never lie, George.
Well, okay, Daniel. I'm gonna go talk with the judge. Hold tight. The bailiff will come get you when the recess is over. Okay, listen, Daniel. The prosecutor is offering another deal.
Why? Why are you telling me this bullshit? We picked half the jury.
This is a very important part of trial. Daniel, this is where you can win. Can't. Keep going back and forth with you about this. Daniel, if I don't tell you any of the deals on the table, we may never get to a deal you feel strongly enough about taking.
Damn, George. For months, I've been looking forward to watching this habitual lying-ass woman get on the stand and try to convince a jury she was raped a dozen times, never telling her husband, or police till the 6th time. And now you browbeaten me to take a deal.
The offer is felony 1 rape, 8 years release after 5 with good behavior.
No.
All right, just something to think about. You'll probably get her sack lunch soon. I'm gonna go get something to eat. Hang in there, Daniel. Okay, Daniel. I spoke with the prosecutor during lunch. There's another offer.
Man, go ahead with the offer.
The offer is plead to felony 3 felonious assault, 3 years in prison, 3 years probation after your release.
No.
I didn't think you'd go for that one either. If you take that deal, it makes you a repeat violent offender, and that's a maximum sentence. All right, Daniel. I'll let the prosecutor know. Look, Daniel. This deal is something you need to seriously consider.
You gave me all those reasons to go to trial. For a win. Different stories. No rape kit and her friend contradicting her statements. Now it feels like you're leaning.
Okay, Daniel. Felony 3 burglary, 3 years probation, 3 years on the shelf. And the indictment for the child goes away.
But George, you said we can win. What about the cross-examination? Huh?
Daniel, who needs cross-examination when you got a receptive prosecutor? She does like to cross her T's, so she said she's not going to do the deal unless you sign for a continuance for next month. On the child case. Technically, she can't drop the case until she gets all the lab testing back.
So I signed this weird-ass deal, but I still gotta come back next month.
Daniel, that deal is an example of just how much time I put in and who I am as a public defender. You went from 2 felony, 1 sexual assault to a felony, 3 burglary with time served. If I can't get you to take this deal, they're going to look at me like I'm crazy, as your lawyer. It's my duty to avail you all possibilities of a win, even if your win looks different from my win. I don't envy you right now, Daniel, because no matter what, I'm going home today. And you have to make a choice whether you go home or go back upstairs. It's real, Daniel. You've been in there away from your newborn damn near 8 months. Think of it this way. Maybe one of the times you guys had sex, it got a little rough. Then maybe you could justify this deal. Especially if it could all be over today. Look, I'm going to give you a second to think about it. I'll tell them you're thinking about it. I'll be back in a moment. Daniel. All right. Are you ready to go home? Are we doing this, or what?
George, this last offer don't make no sense.
What?
How can the indictment for the child go away?
Listen, Daniel. I told you they can indict a ham sandwich, but a prosecutor can drop the charges just as easily, for a number of reasons. Weak evidence witnesses recanting or refusing to cooperate, or making it part of a plea agreement, which is your situation. This could all be a bad dream, Daniel. The deal is yours to take.
Tell me how this works, 'cause it's hard for me to understand how everything ends today.
Okay. You've been indicted for felony 1 rape, but you're able to plead guilty to burglary by way of the Alford plea agreement. When you take this Alford plea, you're saying you don't want to admit guilt, but you acknowledge that the prosecution has enough evidence to likely secure a conviction at trial.
Hell no. That's not what this is. That's not what I'm trying to do, George. Hell no. Not like that. Nah, man. No.
Yes, Daniel. That's the definition of the Alford plea. Whether you like it or not, you're admitting guilt to the original charge. The United States Supreme Court ruled in 1970 North Carolina versus Alford allows you to enter a guilty plea for strategic reasons, even while maintaining innocence. It's looked at as more of a mutual agreement than a bad thing, Daniel. You're focusing on the wrong aspect of the deal. No rape charges. And you're out of this God-forsaken place today.
What about the judge? He been mean mugging. Ever since the Jewinator lied about the semen.
The Jewinator. Daniel.
Her name's Jewett, she's acting like a Terminator. I call her Jewinator.
Right. And still, the Jewinator offered you a hell of a deal.
Because she really believes I did that shit, huh?
Okay, Daniel. You asked about the judge. Don't worry about the judge. He's not just a referee. He knows about everything that goes on in his courtroom. Now, it's the end of the day. You going upstairs, or are you leaving? Just know, this deal will not be here tomorrow.
Daniel took the deal. Are you not surprised? Would you have? Anyway, when they got in the courtroom before the deal was to be signed, there was no jury. Just the public defender, the prosecutor, the stenographer, and a couple officers. You could hear a mouse piss on cotton. It was an ominous scene, no doubt. The judge asked Daniel if he had been given anything special or promised something with the plea agreement. Daniel said, yes. Daniel and George talk in court.
Daniel, what the hell are you doing?
I was promised something, George.
Yes, Daniel. Everyone here knows that. But I told you we are not to mention the deal we made in the holding cell while we're in the courtroom. I told you what to say when you took the deal. He's going to ask you again.
The judge asked if Daniel had been promised anything again, and Daniel said, no. Then the judge asked if Daniel understood. Daniel said, yes. The judge accepted Daniel's guilty plea, and then said, who knows what will happen with this other case? Daniel and George talk after.
What is your problem? You get a great deal. The deal of all deals. And you try that bullshit, everyone's working with you. Just know, the prosecutor has all the power. I'll stay in touch, Daniel.
Yeah, I'm gonna go eat a fresh fruit salad. Thank you, George.
When a defendant takes an Alford plea, the charge they plead to does not have to be the original charge, but it must be legally related enough for the court to accept it as a valid resolution of the case. Attempted burglary is not directly or inherently related to first-degree rape, but it can be legally connected if both arise from the same incident or factual circumstances. If the alleged attempted burglary was part of or led up to the rape, then they might be considered factually connected, but if the rape and burglary happened at separate times or have no factual overlap, it would be highly unusual for a judge to accept such a reduction in degree to an unrelated charge, even if the prosecutor's is reducing charges to spare a victim from trial. Judges must still ensure there's a factual basis for the new charge, attempted burglary. So if there's no evidence of a break-in, it wouldn't hold. The plea must be truthful to the facts, even under Alford. You can't plead to a crime you clearly didn't commit unless there's evidence to support that charge from the same event.
From the time Daniel signed that deal to the time he was across the street at the marathon calling his sister was 45 minutes? That's hella fast. And if you know anything about the Franklin County Jail, that's not just hella fast. That's magic.
Daniel went to trial December 13th, 2011. And if you look at his case detail, you'll see. On December 13th, 2011, was a jury trial with a plea. Now, if they only picked half the jury, then there was no jury trial. And looking at this, you would never know the offers proposed or turned down, let alone know that this man went from felony 1 rape to felony 4 burglary, which is basically a misdemeanor. And if you did know these things, you'd wonder who the hell his lawyer was, and how did he swing such a deal? The judge. That's how. See, with an Alford plea, The judge must be satisfied that there is a factual basis for the plea, meaning, even though the defendant says, "I'm innocent," the judge cannot accept the plea unless there's real evidence, like witness statements, forensic reports, video, etc., that could likely lead to a conviction if the case went to trial. Why is that necessary? Because a guilty plea, even an Alford plea, results in a conviction. The court has a duty to ensure people aren't wrongly convicted without some credible evidence to support it. So, before accepting the plea, the judge will usually ask the prosecutor to summarize the evidence they would have presented at trial, and review police reports, witness statements, and lab results if they exist. So either the judge heard everything you heard about the first rape indictment and came to the conclusion that Daniel would be found guilty, or he was going to accept it no matter what, because that's who he is. Nonetheless, part of a judge's job is to make sure that the decision for the defendant to take the Alford plea is based on real evidence, not just fear or pressure. When Daniel shows up for court, he finds out that the prosecutor did not drop the case. There's another continuance. Daniel and George speak afterward.
What the hell is this? George, I would not have waived my rights and plead guilty by signing that deal if I knew this would happen. This can't be legal. How can she do this?
I know there's nothing I can say to help Daniel, but I'm sorry. I had no idea this would happen. It's always a possibility. Because the prosecutor holds all the cards. But this is never something I would expect from her.
I just know. This is some bullshit. I feel like you played me, George. Can't you file a lawsuit? Or a grievance? Or something? Fuck.
You think I wanted this to happen? Think of it like this. A guy takes a plea deal. The prosecutor doesn't recommend any time. Guy goes to his sentencing. Judge gives him a year. What happened? The prosecutor, behind closed doors, tells the judge, give him a year. On paper, he recommended no time. How the hell was his lawyer supposed to know? You can't blame me for that, Daniel.
You're the one who browbeat me with those deals. Then you no doubt begged me to take it, even though you knew.
Okay, Daniel. Number one, creating a sense of urgency in the moment is not me begging. It's me being your advocate. I know deals like that don't come around that often. Daniel, it's a good deal. That's why you took it.
It was never a good deal. And even then, I didn't want it. Because I didn't do it. God damn it. Now I've pled guilty to it. And this lady Jewett, not only is she, how can she do all this backwards ass shit?
Daniel, all your points are valid, and I know you're disappointed, to say the least. But you need to step back from that and realize you still have a problem to sort out. They have your DNA on the crotch of a diaper.
The jury needs to know about the detective's propensity to fuck with the evidence. The diaper in particular, which, last time I checked, was illegal. So as long as you ask the right questions, and not the good questions, I don't have a problem, George.
Look, Daniel, we'll cross that bridge when we get to it. Right now, though, I have other business to attend to. I'll call you in a few weeks so we can hash out a game plan as far as the jury trial.
Bye.
Okay, Daniel. I remember you mentioning going after the detective, so the jury can know about his evidence tampering habits. Well, here's the thing. You're going to trial with a kiddie case.
So what?
Listen, I don't think you should have a jury trial.
Listen, I need 12 people who don't know each other to see this circumstantial evidence and all the reasonable doubt. And it'll be what it is, George.
Look, Daniel, in a case like this, alleging child sexual abuse, the emotions run extremely high, and picking an impartial jury can be incredibly difficult. Many folks walk in with strong biases. There's no middle ground, so with circumstantial evidence, you're taking a bigger risk than you think. And some people don't even realize how their personal experiences or beliefs could affect their judgment in these cases. Even though we have the right to a jury trial, we have to consider whether a judge who understands the law, the rules of evidence, and how to set aside emotion might give us a fairer shake. You got to think seriously about whether a bench trial could be a better option here, Daniel.
I don't want to do that. I don't feel that's something I want to do. I just don't like that idea.
Is it because of your many years of law school, or maybe your decade of experience as a criminal lawyer, probably? You can't say no without a reason, Daniel.
Because I'm facing life. In this situation, I'd rather have 12 people. No matter what, I'll see you at the next court date.
All right, be careful out there, Daniel. Think about the bench trial.
There was another trial date. There were no deals offered. There was another continuance. George and Daniel talk outside Judge Bender's courtroom.
Daniel, I'm telling you, you're taking a big chance with this circumstantial evidence. Even with weak evidence, a jury could feel sympathy just, because it's a child. It's literally hit or miss, and with trial hit or miss is bad.
I hear what you're saying, George, but I'd rather have 12 people who don't know each other than a panel of dry-ass judges from the same county.
A jury for a child case is completely unpredictable, Daniel, especially since we more than likely will have to ask them if they've had any sexual trauma and whatnot. Who the hell is going to tell the truth about that? Let alone be impartial to somebody with a charge against a little kid. A panel might not be a good idea.
What about them mystical-ass statements Stanisha made? Can we use those? How do they tie in?
We can't ask Stanisha anything about the rape case against Stanisha. It's called a rape shield. It was put in effect to protect rape victims, mostly prostitutes or women who had a history of being loose or promiscuous at any time before the alleged rape.
Man. A rape shield. So since that case is over, because I took that plea, you can't say nothing about them unbelievable stories while she on the stand. Wow. That deal is looking better and better, George. It just keeps on giving.
Daniel, that deal is the reason why you're not breathing that recycled air in the county jail. If you continue to stay stuck on things we can't change, how can we get a different result? You're the one facing Buck Rogers time. Get focused and get a grip. Because you're making it harder for me to help you get your ass out of a lifelong sling.
I appreciate being free from jail, but I don't feel free. This stress was supposed to be over, and you convinced me of that. Now you're telling me to get over it, so we can deal with this other, also equally fuck shit you're in charge of. Have you won at trial? Or have you just had a lot of trial deals that you feel you've won? There's a difference.
To answer your disrespect, Daniel, yes, I have won at trial, and I won because I did it right, and the right way for you, and this trial is a bench trial, with just one judge, Judge Bender.
Why would we do that? He presided over the last trial.
Yes, that was a jury trial, though, Daniel. Now, you said you want another trial. I'm saying I don't think a jury is a good idea. You won't budge. We need a compromise. So, I'm giving you options, because life without is life without. It means you don't get out.
So, the judge can know shit about the case that the jury would never know. But you can't bring up the multiple unbelievable stories she seemingly made up as she told them. My common sense don't see no sense in that, George.
That's cause your common sense wants this to be fair, and the situation is not fair for you. That's why you need a fair judge. And Daniel, you gotta trust me on this. Because I know Bender is as fair as they get.
It sounds like a good scheme. But I still feel like a jury is my best option, George. No, I don't want a bench trial.
I hear you, Daniel. Okay, look. It's fresh in your head about the bench trial being Bender, and him being the only judge. Just think about it, Daniel. We're going to stretch this out as long as we can. We already got all the evidence. We just got to get you on board with the right trial. Go enjoy your day, Daniel. I'll be talking to you soon.
Yeah, later.
As George instructed, Daniel waived his right to a speedy trial, and though he tried, George was once again unsuccessful in getting Daniel to accept the bench trial, but the pressure was still on. The prosecutor, Megan Jewett, is preggers, and she asked for a continuance for a September 2012 date, but the judge continued only until April 23, 2012, 4 days later. George told Daniel to come to the courthouse early to get started on their defense strategy.
Hey, Daniel. I thought it would help if I had one of my coworkers talk to you about what you are actually facing. This is John Keeling. He's an appellate lawyer. He knows all too well how many people make the wrong decisions at trial, and people who shouldn't have went to trial in the first place and end up losing big.
What's up, Daniel? George has been telling me you need some convincing. I've known him for years, and he rarely gets emotional about a case.
I've been doing this a long time, and I'm telling you, if he chooses a jury trial, he's walking into a damn trap. We've got zero control over how a jury is going to react to these charges, and with something this serious, they don't need much to throw the book at him. Natural life, just like that.
Look, Daniel, we need you to understand how serious this is. If you go forward with a jury trial, you're handing your life to 12 strangers who may not understand the law, the evidence, or the nuance of this case, and that gamble could cost you natural life. Juries are unpredictable, especially in cases like this, where emotions run high and the details are sensitive, and all it takes is one juror with a bias or a misunderstanding to send you away forever. We're not just worried about losing a trial. We're worried about living with you getting life when you didn't have to.
Daniel, if you go in front of a jury, you're putting your entire life in the hands of 12 random people who don't know each other, as well as the law, the way a judge does. They could get emotional, confused, or even just not like how you look. And if they convict, you're looking at life in prison. No chance of getting out.
They might convict you just because the charges sound bad, not because the evidence is solid. A bench trial lets you argue this case to someone who understands the law, who sees through theatrics, and who we can trust to weigh the facts, not the drama.
A bench trial, just Bender, gives us a guarantee at a fair outcome, because the judge knows how to focus on the weak evidence, not feelings. The prosecutor wants a win so she can boost her career, and you're the perfect target for that. It doesn't matter if it's right or fair, but if you keep the jury, you most likely will be making it easier for her to win. Daniel, you got to trust me. Tell him, John, there's no way. A judge will convict you of this crime without actual physical evidence. No way.
He's right. All the evidence is hearsay and circumstantial. No way a judge convicts you of this particular crime. But a jury can, cause a jury won't be able to look at it with an analytical mind, like a judge. I'm not saying a bench trial is a sure win, but it gives you a fighting chance with someone who knows how to simply apply the facts with the law for a fair trial. Isn't that what you want? A fair trial?
I never looked at it like that. Not taking anything away from the way you put it, George. But let me think about it.
Okay, Daniel. You've had your eureka moment. We need you to sign this jury waiver now. What's there to think about? Trial starts in 3 hours.
Okay, George. I'll sign the jury waiver so we can have Judge Jonathan Bender preside over my second trial in courtroom 4D. Because that's what you believe is best.
A judge being in charge of 2 separate sexual assault cases that both involve the same man and 2 women from the same family, mother and daughter, raises some big concerns about fairness. Judges are supposed to be neutral, even if they aren't actually biased, but if it looks like they might be biased, that's a problem. If the judge already handled a case involving the mother and now has to rule on a case involving the daughter against the same man, it might seem like the judge has already made up their mind, or probably has too much background to be fair. There are rules that say a judge must remove themselves from a case when people could reasonably doubt the judge is fair, when the judge personally knows details about the case that weren't said in court, or when the judge was involved in another case with the same people and the two cases are closely connected. It's sometimes allowed by law, but it's a bad idea if it even seems unfair. In this kind of situation, the judge probably shouldn't be involved in the second case, in most cases like this, when a lawyer is trying to win. He would have a strong reason to ask for a different judge. Someone at the Franklin County Clerk of Courts must have felt the same way. If you look at the criminal case detail for the second indictment for the sexual assault case against the child, case number 11, CR 004725, you'll see that, as of today, July 10, 2025, the judge's name has been changed from Jonathan Bender to Andrea C. Noble. The courtroom has been changed from 4D to 6F, and Daniel's attorney's name has been changed from George Schumann to no attorney on record. And the prosecutor's name has been changed from Megan Jewett to Thomas B. Vaccaro. If you look at the case detail for the first case, the one Daniel took the bogus plea for, case number 11, CR 003166, you'll see that the judge's name, the courtroom, and the prosecutor's name has been changed as well. Only George's name is the same in that case detail. Hell. If you didn't know what you were looking for, you would think this all looks on the up and up. But it's shady as fuck. I wonder if Judge Noble and the prosecutor, Vaccaro, know that their names have been added to cases they never presided over or prosecuted. How could they not? Minutes before trial, the prosecutor offered one last deal. The deal was plead to third-degree gross sexual imposition and 3 years in prison. Daniel said no. When the trial began, Daniel could see the prosecutor and 3 witnesses were visibly pregnant. He was still hopeful and positive that he would win at trial. Daniel's cousin sat in the very back of the courtroom next to the door until the prosecutor instructed him to move up front and sit right behind the prosecution. The prosecutor, in her opening statement, admitted that all the evidence is circumstantial, but she would prove that Daniel committed rape by cunnilingus. That's what the charge was. One by one, all the witnesses were questioned, and all the witnesses that George asked the question, was there any evidence of rape? The answer was, no. All the witnesses called, whether for the prosecution or the defense, said, no. There was no evidence of rape. And no. George did not ask the detective about how the diaper went from Stanish's hands to an officer's hands before the interview, but then end up on the floor in the picture taken after the interview. Pictures taken by the detective. And no. George did not ask the detective anything about why the detective left all the evidence in his office for 3 days in the open air to dry, risking contamination. George never asked anything accusatory of the detective at all. But when Daniel asked him to ask Stanisha if she ever had consensual sex with Daniel, George asked. Stanisha said, no. We know the trial lasted only 4 days, because Daniel signed the jury waiver on the 23rd of April 2012, the first day of trial. And the court reporter signed the receipt for the 26th of April 2012. The receipt is only signed the last day of trial. Looking at the case detail, you wouldn't be able to tell if there was a trial at all. On the last day, Judge Bender found Daniel not guilty of rape by cunnilingus, but since there was no jury, he didn't have to ask a jury to find Daniel guilty of gross sexual imposition. He did it himself. Daniel asked in open court, "What does that mean?" The judge said, "I can convict you of GSI for touching an earlobe." What Daniel didn't know was, GSI is a serious, catch-all type charge that covers sexual contact that's inappropriate, unwanted, and often forced, but stops short of rape. It's still a felony, and depending on the details, like the age of the victim, it can lead to long prison time and sex offender registration. Once the judge convicted Daniel, he gave his reasoning in open court that he thinks something happened. Then he revoked Daniel's bond. George and Daniel talk after he is found guilty.
You won, Daniel?
What the fuck is you talking about, George?
You didn't get life, Daniel.
Fuck this shit.
Listen, Daniel. Listen to me. By convicting you of GSI, Bender violated your 4th and 16th Amendments. You got an appeal coming. You got an appeal coming. I'm telling you, Daniel, he can't convict you of a crime that's not on your indictment. That's illegal. I told you having a bench trial was your best bet. The judge screwed up.
This is fucked, George.
Daniel, look, it may seem bad now, but in 6 months to a year, you're going to be good. Only thing is, you're going to have to do time till you win your appeal and get your appeal bond. Also, Daniel, you're going to want to waive the PSI. If they do a pre-sentence investigation, they sentence you based upon your actual criminal history, you'll probably get the max. You don't want that. Plus, when you waive the PSI, you won't have the usual 2 to 3 week wait to transfer to prison. I know you don't want to sit in Franklin County any longer than you have to. All right, Daniel, I can see you. Don't want to talk? I get it. Look, call me tomorrow. I'll be in my office. Good night, Daniel.
George didn't just use his colleague, John Keeling, to push for a bench trial in order to keep the truth buried. He went even further. He advised his client to waive the pre-sentence investigation, not as a matter of legal strategy, but because he knew exactly what that report would reveal and who it would expose. In most serious felony cases, especially violent crimes, sexual offenses, and those involving children, a PSI isn't optional. It's mandatory, or at least strongly recommended. Why? Because it gives the judge a full picture, the defendant's background, the impact of the crime, the risk of reoffending, and crucially, the victim's voice through an impact statement. Skipping that report isn't just skipping paperwork, it's skipping accountability. Even though the client pled down to burglary, the PSI would have documented the original rape charge involving the mother, any inconsistencies in prior behavior. By waiving it, they erase the trail. And if a judge signs off on that waiver, knowing full well what it hides, then we're not just talking about a shady deal. We're talking prosecutorial misconduct, judicial misconduct, possibly ineffective counsel, and maybe even conspiracy to obstruct justice. No PSI means no red flags, no scrutiny, no record. It means the victim's family and the public are left completely in the dark. This wasn't a clerical decision. It was a calculated move to suppress the truth, manipulate the system, and protect not the client, but the lawyer, the judge, and the backroom deal they made together. The documents on the screen are transcript pages from Daniel's sentencing hearing. If you'd like to read the exact words and legal jargon, pause the doc and enjoy. But, to paraphrase, George was arguing that prison time shouldn't be mandatory for Daniel because,
Your Honor, when it comes to the mandatory sentencing rules for GSI, I made 2 main arguments in my sentencing memo. First, based on U.S. Supreme Court cases, like Apprendi. If the court wants to increase someone's sentence because of extra facts, those facts need to be decided by a jury, not just the judge. Now, yes, we gave up the right to a jury trial in this case, but only on the charge that was in the indictment. That was the only charge. We didn't put on a defense specifically against the GSI charge because it wasn't part of the original indictment, so we don't want the court to say that by waiving the jury trial, we also gave up our right to argue under Apprendi that any sentencing enhancements should still be decided by a jury.
Then the judge says,
By choosing a bench trial, just me, no jury, you also gave up your right to have a jury decide anything that could make your punishment worse. That's the deal.
Right? But not GSI. He wasn't charged with GSI.
Yes, you absolutely did give up that right, because it's a jury's job to decide the facts. When there's no jury and I'm the one deciding the case, I have to do the same thing a jury would do. If I don't find enough evidence to convict you of the main charge, but I do find enough evidence for a lesser charge, like I did here, then that's my job, to make that decision based on the facts. You didn't lose any rights by waiving the jury, because even if you had a jury, I would have told them to consider that lesser charge anyway.
And your position was that GSI is a lesser included offense?
Absolutely it is. I cited case law at the time.
the judge gave Daniel 5 years, which is the max. So George's idea that waiving it will stop Daniel from getting the max was not accurate, nor was it true. George and Daniel talk after sentencing.
Okay, Daniel, now we get ready for victory.
I'm going to write the Bar Association. I want to write a grievance against the judge. You say he violated my rights, so I demonstrate my rights. Simple as that.
Daniel, I get that you're angry and feel like your rights were violated, but filing a grievance right now, especially one based on that kind of claim, could seriously backfire. If you accuse the judge of convicting you of a crime that wasn't on the indictment, they're going to shut everything down and deny your appeal before it even gets started. The smarter move is to let the appellate process play out through someone who knows how to raise these issues the right way without triggering retaliation. If you want any real chance at reversing this, you need to hold off, or you'll end up closing the only door that can still get you out. That's not a good idea.
I'll think about it.
Daniel was registered as a sex offender before he was sentenced. And since he waived the PSI, he was transported to prison within a week. Now, we all heard the judge say that there was case law establishing GSI as a lesser included offense. But Daniel didn't understand the legal jargon, so Daniel took the advice of John Keeling when he got this letter in prison.
Dear Mr. Cundiff, I will attempt to answer some of the questions you raised in your letter. If you win the appeal on the issue that you were improperly convicted of an offense that is not a lesser included offense, you will not have to go through another trial. The judge essentially found you not guilty of the original offense, but guilty of one not charged on the indictment. The appellate court would vacate your wrongful conviction, and you would go home since you were found not guilty of the original charge. I have handled several appeals in the past where the issue involved whether or not the offender was properly convicted of a lesser included offense. You cannot sue the judge or the state, even if the appellate court rules that you were improperly convicted. Judges have absolute immunity from such lawsuits. There are situations where police officers can be sued for illegal searches, but such suits are complicated, and it's difficult to show that their conduct rose to the level needed to allow for any damages. I am not available for such a purpose, and you would have to find a private lawyer to pursue any such remedy. Given the facts, it is unlikely that you would be able to obtain representation in this regard on a contingency basis. You would have to pay upfront money of a sizable amount if you want to pursue such a claim. I would strongly recommend against the filing of any grievance against the judge. We all do stupid things in life. If you filed such a grievance, it would be one of those stupid things. You have my assurances that absolutely nothing would come of such a grievance that could benefit you or hurt the judge. Absolutely no action would result from such a grievance. If you file such a grievance, I will withdraw as your attorney immediately. My job is hard enough without you doing something stupid to make it harder. I will send you a copy of the brief when it is finished in about 2 weeks from now. I just got back from a trip up the Amazon River in South America, and I will start working on your appeal tomorrow. The fact that you are in a program is of no consequence to your appeal. If you have any questions, please feel free to contact me. In the meantime, please heed my advice and don't do anything stupid.
Now, let's be clear. The lawyers were right about one thing. That grievance, it wouldn't have gone anywhere. The system isn't built to police itself. It wasn't going to expose a judge for bending the law or a public defender for betraying his client. It would have been stamped dismissed before the ink dried. But don't get it twisted. They didn't shut it down to protect Daniel from wasting time. They shut it down because they didn't want anybody looking too closely. Because if someone did, they'd see the whole house of cards, the backroom deals, the buried reports, the silent cooperation between the bench and the defense. 2 cases, same courtroom, same players, and a quiet agreement to keep the truth out and the record clean. So instead of letting that grievance draw attention, they chose to write something else. A bomb. A legal brief, dressed up in strategy, but loaded with misdirection, meant to bury the facts and seal Daniel's fate. Because if this case ever sees the light of day, it won't just embarrass them, it'll expose them. And the truth don't need a robe or a bar number. The truth just needs a chance to speak. And now it will.
Now, let me tell you something. If you ever find yourself caught up in this system, I mean really caught up in something felonious, don't make the mistake of blindly trusting your public defender. Some will fight for you, but some are just there to move you along, nice and quiet, like a cog in the machine. Let me break this down for you, step by step, the appeal process, because this is where they count on you not knowing the rules. First, after you're sentenced, you've got about 30 days to file something called a notice of appeal. That's your one shot to say, I don't agree with this. I want a higher court to look at it. But here's the catch. Some defenders won't even tell you about that deadline. Or worse, they'll shrug it off and say it ain't worth it. That's not just laziness. That's your freedom they're brushing under the rug. Next, The court gathers all your case material, trial transcripts, evidence, motions, into what they call the record. That's what the appeals judges read. If something shady happened in your trial, this is where it shows up. If, and that's a big if, your lawyer includes it all. Leave one piece out, and suddenly the story don't add up. On purpose? Maybe. Maybe not. But the outcome's the same. You lose. Then comes the part that either saves you or sinks you. The brief. That's a long letter your appellate lawyer writes, breaking down what went wrong. Whether the judge stepped outside the law, the prosecutor cheated, or your rights got stomped into the dirt. That's where your defense should stand tall and call it out. But let's keep it real. If your public defender is more loyal to the judge than to you, they're not going to say a word. They'll write around it, dance around it, protect their mistakes instead of correcting them. And in my case, that's exactly what happened. The judge already said it clear as day. GSI, gross sexual imposition, was a lesser included offense of rape. That was on record. Case law supported it. No confusion. But my appeal was written as if GSI wasn't a lesser included. That was the whole argument. An argument that had zero chance of winning. And guess who wrote it? My appellate lawyer. My public defender's colleague. His friend. Now ask yourself, why would a professional write an appeal built on a legal lie? Why would a trained lawyer ignore what the judge already said in open court? One reason. It was written to lose. Sometimes the court will give you a hearing, oral argument, where the lawyers talk directly to the judges. But don't count on it. Most of the time, they just read what's written and make their decision. And if your lawyer gave them a weak argument, a false argument, or no argument at all, guess what? You're done. They can keep the conviction, throw it out, or send it back for a new trial. But if the real issues were never raised, you'll never even get to that choice. My appeal went all the way to the Ohio Supreme Court, and they denied it. Why? Because GSI is a lesser included offense of rape. That brief, the one that was supposed to save me, was never built to win. It was built to fold. So let me give you this final truth. Don't just assume your public defender is on your side. Some are good, some will fight. But in this system, some are friends of the system. And in this system, friends protect friends, not you.